Welcome back to another episode of Beyond the Bench. This is our now second episode with Jim Kerwin, our free speech, all things free speech, where we talk about just in general, all things law, as well as our key to advocacy and success here at MSLF. And yeah, I'm excited. Honestly, there's a lot of stuff I don't know about free speech. So I guess the abstract question that we can kind of kick it off with is, who are you?
Well, first of all, let me just say thank you for having me, Noah. It's great to be here. I'm excited to talk about free speech, not so much about myself. Who am I? I'm a lawyer. I graduated from UC Berkeley School of Law quite a while ago and did commercial litigation for a bit in New York City and then kind of shifted to what I'm doing now, which is really fulfilling. We're defending the Constitution in court. Pretty much that's what we do now. That's what I do now. So that's who I am.
Kind of going back a little bit is that bridge of going. You said you were in New York law for a while, and I did some research, and it looks like you've been working in law since 2006, 2007.
Yep, that's about right.
What was that bridge like? You know, like going from New York law all the way to constitutional law. That's a big jump.
Yes, it is. I mean, when you go to law school. Or at least when I went to law school, I did not have in my mind visions of myself staying up 60 hours a week doing document review, which is what you do in big New York City law firms. I thought that I would be doing something more meaningful. There's a lot of money that they offer you. I did some clerkships, and so it's kind of hard to resist. So you do that for a while, and then you transition to what you really want to do,
yeah.
which is this.
Did you, what was your philosophy, I guess, coming out of law school? Like, I guess, what was that foundational element that drove you to going to law school in the first place?
That's a good question. I mean, I've had a lot of shifts in what I wanted to do. I originally saw myself as a public defender type, and I did a lot of clinical work when I was in school with, like, housing clinics and things like that. So public interest work. Not so much constitutional law, as more kind of on the ground, helping people with their individual problems. Philosophically speaking, I don't have a good answer to that. I think that the First Amendment is awfully important. So I'm glad that I have the opportunity to work in that area now.
What kind of brings you to MSLF, and why keep fighting for free speech? Like you said, it's important. So what in your mind, what makes it important as a constitutional right, as a basic human right?
So I think it's kind of the most fundamental right that we have for, we live in a democracy, and the idea of that is that people are supposed to be participating and having their say. But if you you can't even get off the ground if you are not free to express yourself fully, and that goes from not just necessarily direct government censorship, but there's things where government might encourage private parties to censor views, and there's cultural aspects to it. The cancel culture of the last 10 years or so was really an eye-opening thing for me and got me worried a lot about the direction of the country, and so that's one of the reasons why I do this work too. Yes.
And if you could, I guess, for someone who doesn't know anything about free speech, how would you define it as either a simple term or just what's your definition of free speech?
Well, the constitutional rule is that the government is, the text is pretty simple, and that actually makes for a lot of complexity. The text is just Congress shall make no law abridging the freedom of speech, which doesn't tell you a whole lot.
Very gray. Very, very gray.
So in this area, there's just kind of a lot of context in which these claims arise, and the first thing you do is sort of organize your thinking around, well, what's the context that is coming up? Is it just who's the speaker? What's the forum that they're speaking in? That kind of thing. A lot of our cases involve schools. So government-run schools have raised particular issues because students, depending on, and there's different issues at different levels of schools. As you might imagine, K through 12 students have you might think somewhat less ability to just say whatever they want to say in the middle of the school day. Universities are different, but all of them, at least when they're government schools, may have First Amendment problems around student speech, things like that. We have some public employment cases, and then we have some straight up, well, actually there's not too many of those at the moment, but like the sort of paradigm case would be just somebody wanting to go talk on a street corner, and can the government stop them from doing it? That's kind of the most basic interaction between government power and free speech.
Well, now you're getting cases like Murphy versus Missouri, where you're getting into the weeds of social media and who controls it, what's the algorithm, who can comment, who can talk.
Yeah.
That's just, I don't know. Like you said, there's a lot of gray space in the definition of free speech.
Yes.
I think that leaves a lot of room for making rules, but I guess my next question is, what are the rules, or if there is any, for free speech, and who makes those rules?
Well, it would matter a lot what the context is, right? So who makes the rules the Constitution has the basic framework, but as I pointed out, it's pretty terse. So it's mostly judicially fleshed out, right? And those rules, what the rules are, that's a very difficult question to answer, because it would, again, kind of matter a lot about what the context is. So just to take an example, government employment, right? That's an area where government hires a lot of people to do jobs, like, there's a sanitation worker, right? As with any other employer, the government in those kinds of contexts has some interest in what its employees have to say. So the rights of government employees to free speech is somewhat more limited than your right just walking down the street holding up a political sign or something like that. So in that context, there's a huge body of law. A lot of this stuff goes back to the Warren Court era, which is where a lot of the original frameworks that we work with nowadays, not entirely, but some of it does. There's a complex series of questions you ask for government employee speech. We have a few government employee cases, right? So there are our Danielle Johnson case in Oregon, for example, involves a woman who worked for a state agency in Oregon, and she was subjected to a lot of very aggressive DEI practices, and they also run affirmative action programs, and she questioned whether these things were legal. She has a First Amendment right to do that, and the employer, on the other hand, thought, oh, this is disruptive because we really want to push these ideas, and she's questioning what we're doing, so we're going to, they demoted her, and they investigated her for microaggressions and things like that. The legal issues come down to these questions about, it would be obviously illegal for the government to just retaliate against you standing on the street corner and having this view. I think the state of Oregon is violating the Constitution. They can't come after you and throw you in jail. It's a somewhat different question when they say, but you're my employee and you're disrupting the workplace because of what you're saying.
There's a separate distinction between those two.
It's a big difference between so the legal questions are much more nuanced and complex in her case. Though I will say, while the legal framework might be complex in her case, it's pretty obvious that they did something wrong. You can't. Your employees are allowed to ask whether you, as a government employer, you're spending taxpayer money doing something illegal. That's, they can't shut you up by demoting you. So that's that case. Yeah,
correct me if I'm wrong, isn't there a distinction between making a complaint as part of your job compared to as if you are a citizen or just normal outside employee? Or?
Yeah, that's right. So there's one of the first questions you ask in these public employee cases, really what the question should be is whether you're acting as a mouthpiece for the government. That's what these cases originally started as. So let's say your job is to be the press secretary to the President of the United States, and he would like you to say X, and you go in front of the cameras and you say Y. And can you get fired for that? I mean, you might have every right to, when you're not at your job, to just tell people, I believe Y, even though that conflicts with what your boss wanted you to say. But you don't have that right as a public employee when it's your job, right? So that would be a very clear example of not having a First Amendment right to say what you want to say. So it can get more complicated than that. I don't. That's not a real issue in Danielle Johnson's case. It definitely was not her job to police the state of Oregon's compliance with the 14th Amendment. She works in environmental cleanup. This is the agency she works for. Is an agency that deals with the environment in Oregon and has nothing at all to do with DEI practices. So, yeah.
And you stated that this case kind of involves government officials trying to silence what is citizens' criticism, almost. And why do you think that's such a dangerous precedent for free speech?
I mean, if people don't feel, this it's the hallmark of totalitarianism for government to tell you what you can say and what you can't say. I mean, that's about as basic as it gets, for me anyway. And this is what a lot of the case law is about. The government will say, well, that's not what I'm doing, because really, just like any other employer, I care about what my employees have to say, because I don't want them disrupting. I don't want them, running up and down the hall in the middle of the workday, chanting protest slogans.
Yeah,
and probably an employer would be able to stop you from doing that, because they have an interest in people getting their work done, right? So that's what this is all about, right? But in reality, they're just using it as a cover, right? She's not disrupting the workplace in any way that's cognizable. She has every right, again, to blow the whistle on her public employer, and point out when they're violating the law. So,
I think there's also this concept of listening to both sides, and I think obviously when you write these what they call like amicus briefs or so along those lines, you kind of have to listen to the other side. So was there any arguments that were kind of surprising or like shocking, I'd say, or telling about, I guess, the 180 perspective of who's on the other side of this case?
On this one in particular, this is not an amicus case. This is a direct representation case.
Yes,
so
my apologies.
That's all right. Well, the procedural posture is somewhat complicated. We on the other side of the case is the Oregon Attorney General's office, who defends all of the state agencies when they're being sued. And they didn't say anything that surprising, though. The way this case happened is that it was referred to a magistrate judge for a recommendation on a motion to dismiss. And the magistrate judge kind of went out of her way to, in my view anyway, to kind of adopt a DEI-oriented worldview, and she kind of put some things in her opinion that just made it sound like there can't be any legitimate debate about whether there are such things as present-day systemic racism or white privilege or stuff like that. Whatever you think about those ideas, they're, in my view, a matter of debate. They're not just things that are true and can't be questioned. And some of the flavor of the magistrate judge's opinion seemed to go the other way. We had some success, though. We actually had that opinion overruled by the district court judge, so that's what, the case is moving forward. But that was somewhat surprising to me. And I guess that ties in with speech, because there is a worldview out there that claims things like speech is violence, right? And this is all wrapped up together with views about society being nothing but oppressors and oppressed, and there isn't any neutral ground for anybody to ever stand on when they're discussing controversial ideas. You only sort of speak for your class as, oppressor or oppressed or something like that, and your speech can be violence and that kind of stuff. These are getting kind of academic, but these ideas are out there, and to the extent they might be adopted in judicial opinions, I think that's a big problem.
You touched on speech becoming violent. So do you think we're seeing a rise in government bodies trying to suppress speech, or was this case more of an outlier, in your opinion?
Interesting question. I think it's a sad truth that there's just perennial efforts by, once anybody gets their hands on the reins of political power, it seems to be very tempting to try to then silence their opponents, right? It happens throughout history. I think one area where I'm quite disturbed that things do seem to be getting legitimately worse is university campuses. And a lot of that's more kind of cultural, and again, these sort of dominant ideas about the lack of value of free speech and things like that. That seems to me a big difference. I'm a little bit older than some of my colleagues, and I went to school in the early 1990s, and there were never any questions about you can't say that because it hurts my feelings, or I need a safe space so that I can avoid your disturbing comments in the middle of the class. It was nothing like that at all. You were encouraged to say controversial things, and even if they upset other people. Now it seems like the culture is very different. There's people walk on eggshells because they're concerned about upsetting other people, and they're also concerned about blowback and about the university not having their back. We have this case in UCLA right now, which is kind of this very scenario. There's a pro-Israel speaker was invited to the UCLA campus during a lot of activity by anti-Israel activists at school, so the pro-Israel speaker went through all the right procedures and reserved a room and all this kind of stuff. That upset the anti-Israel agitators, which is fine. They can be upset, but they basically threatened to shut it down. And the part where the university comes in and the government comes in is that the government didn't do anything to protect the right of the controversial speaker to have his say, right? They basically said, oh, other people are being upset by this. They're going to make a ruckus, so I'm not going to stop them from making a ruckus. What I'm going to do is silence you. That, you asked me if I saw, if I'm concerned about increases in censorship. That's really the area where I think it's getting worse and worse. Is
within higher education.
Yeah.
I guess changing gears then, kind of focusing on this UCLA versus Young America's Foundation, what kind of I mean, you kind of already touched on it, but what really perked your ears on it? What, I guess, points of interest really, I guess, get you passionate about the case?
Yeah, I mean, this came up during that year, the year after October 7th, and there's a lot of news about how there's a lot of activism and intolerance really for opposing points of view on university campuses, and that's very concerning to me because, I mean, for obvious reasons, people, the future leaders of America, for good or for ill, are being funneled through these institutions, and their values are being shaped, and if they're being shaped to not be respectful of, to not be tolerant of even upsetting points of view, that's a real problem, kind of looking forward. So that, that's why it's a case that was very, it's very topical. It's a very important issue. There's sort of a technical legal, not that technical, but there's a legal issue in the Ninth Circuit where this case comes from that's sort of important around what standard are we going to apply to the university's failure to provide any protection to the speaker in this case. The doctrine under First Amendment law that we're talking about is called the heckler's veto. So in a sense, UCLA might say, we didn't stop this person from speaking. It was these protesters. The protesters aren't the government, so the First Amendment doesn't apply. But there is, in a lot of circumstances, it matters who's doing the censoring, who's silencing you. And so in that sense, you might say, well, maybe UCLA is right. They didn't do anything. It was the protesters. But that's not the way that kind of excuse for the government has been for a long time kind of out of bounds because you can't just simply say, well, we've invited the speaker to campus. He's done everything correct. We have a police force that's there to enforce the laws. And now these hecklers are threatening to shut things down and maybe engage in violence. And we just have to throw up our hands. There's nothing we can do. That violates the heckler's veto doctrine, or it amounts to a heckler's veto. So the technical point in the Ninth Circuit is whether that doctrine applies in the specific building this is really what the issue is, in the building that the speaker was in, because it's a university, call it a limited public forum. It's somewhere where they don't have to let just anybody come and talk. All right. Our argument, which we think is right under the law, is that even though it is a limited public forum, they still owe a duty not to allow hecklers to silence speakers.
And would you say there's a difference between public and private schools as well, like when it comes to?
For sure. There's yes. So private schools are not bound by the First Amendment at all. The First Amendment only prevents the government from abridging the freedom of speech. So if you go to a private school as a student, you're basically entering into an agreement, a private contract with them to accept their rules. And if they have,
they don't like you.
You could have a university that just says no. Anybody who expresses an opinion that I don't like,
yeah,
I don't think they'd last for long as an institution, but it wouldn't violate the Constitution.
Interesting. And you stated earlier that you have your foundations at UC Berkeley, at law, right?
That's where I went to law school. Yeah.
What's the difference between, I guess, what you're seeing now in this current case of UCLA and then when you were there back at UC Berkeley? So was it the same kind of premise, I guess, or like?
It's a while ago. Things have changed, as I understand it. I don't spend much time on university campuses other than with my clients now, so I don't see it day to day. But things were different. Certainly in the 1990s when I was an undergraduate, So UC Berkeley is a distressing case. It was the birthplace of the free speech movement in the 60s, right, where it was the trendy thing to do, and I think the right thing to do, whether or not you agreed with the speech with the points of view being expressed. But there were activists who were all about free speech, and now it's a hotbed of the opposite. Don't say things. Free speech. People give lip service to free speech. We're all in favor of free speech unless it's from somebody who's privileged or causes harm to me because of what they're saying. And this whole idea, again, that speech can be harmful, that speech can be violence, that's an idea that's taken hold, unfortunately, at places like UC Berkeley. It's a big problem. So, one of the things we're trying to accomplish with litigation is is to give the administrators the incentives they need, because they're sophisticated enough, I think, to realize that much of what they're doing is unconstitutional. They might not agree with the Constitution, but anyway, there's unless you win some lawsuits and get some injunctions from courts and maybe even damages awards, the incentives are not there for the administrative individuals to do the right thing, right? The incentive they see is if I don't silence the pro-Israel speaker or allow the hecklers to silence the pro-Israel speaker, now there's going to be protests against me, and I might lose my job, and I might get cancel cultured and things like that. So kind of sad for them, but one of our goals is to start putting pressure on the other side. It's like you should be doing the right thing under the Constitution, and if you don't, you're going to be saddled with judgments and things like that.
Yeah, I think we're seeing a larger and larger trend of these, I guess, free speech campus battles, all across the country. And I think this case in particular is setting a precedent or example. But in your opinion, what precedent or example does this case set for other universities across the country?
So I think universities have been getting away with exactly what I was talking about, allowing the heckler's veto to happen on their campuses. There are a lot of famous examples. I think Charles Murray's speech 10 or 15 years ago now at that might have been a private college, but the general idea that a speaker comes to a university and has something at least locally controversial to say, and then a mob organizes and says, we're very upset with this. We want it to stop. You can't say what you're saying because it's going to hurt my feelings or harm me. And the university doesn't do anything to protect the speaker. So they've been getting away with it. This has been happening a lot, and that's the precedent we hope to set, is to start the push back, and to have some counterexamples of art. Well, the university administrators, again, the only thing in your mind can't just be, I'm worried about my reputation on social media. It's got to be, I might get sued and my university might be subject to an injunction by a federal court or damages award. That's what we're hoping to do.
I feel like a large part of this comes down to like you said, money. Might be getting sued. This might cost me reputation. This might cause me status. And I guess that was also one of the interesting arguments we read and talked about, was talking about the heckler's veto. And I remember specifically our senior counsel talking about it costs $100,000 to even activate SWAT teams and stuff like that. So what's your, I guess, point to, I guess, countering that argument that is money a large part of this problem in free speech on campuses with security, with the heckler's veto?
I've never heard any university defend its failure to stop hecklers from stopping free speech on a university campus. Say it would just be too expensive to do it. You don't really hear it. I've never heard that as an excuse. And I suppose there are limits at some point, but these usually aren't SWAT team type situations. We had some things at the University of Utah that we did for YAF before it never got to litigation because they did the right thing. But they were, they had a speaker on campus to talk about trans issues, and hecklers came into the room, and there were 20 or 30 of them, and they wouldn't leave, because they started shouting slogans and preventing the speaker from reaching her audience. And the university, they had enough police officers there, but they just didn't do anything about it. So if the SWAT team is involved, I don't know, that might be a different story. I'm hoping, so far anyway, none of my cases have involved that kind of violence or threat of violence.
In a perfect world, and this is a very hypothetical thing, in a perfect world, what rules or what need to be made or even stripped away in order to ensure free speech is protected, whether it's at the university level? Like, say you were to have a perfect university, what rules would have to be in place or what rules would have to be taken away in order to protect that free speech?
Right. Well, on the heckler's veto thing in particular, there are other issues too. There are speech codes around, what the sort of civil rights law has been twisted so that if you say, there are places in this country where if you say things like, I don't think biological males should be able to compete against women on the women's team, you might be accused of harassing people on the basis of transgender status. That's a whole nother huge issue, which I think those rules should go away. But on the heckler's veto issue, I guess I would want to see this rule. I do think that a controversial speaker doesn't have a right to just come onto campus and have everybody nod along and agree with him. People are going to disagree. That's fine. But the rule needs to be that the universities, they already have these rules. They just don't enforce them. So I think pretty much every university has at least some kind of rule that says if you are disrupting a campus event, like a speaker talking to his audience, you get a warning, and then if you don't stop it, you have to be expelled, and and then potentially you'll get academic discipline, if not referral to the local prosecutor's office, that kind of thing. So they have these rules. A big issue is the enforcement, right? So because they don't enforce it, they let the hecklers keep heckling, and they allow them to silence the speakers, and it goes on until the lawsuits come, and hopefully we'll be able to push things in the opposite direction.
So there's a disconnect between federal and state officials or even local administration or officials as well.
There aren't any federally run universities that I know about, so it's just not an issue.
Well, the enforcement of free speech and
it can be. It depends on who's doing the talking, who's in charge of which level of government. Like I said before, unfortunately, speech violations seems to be a big temptation for anybody that gets into power to want to use the power of government to make their lives easier, right? By silencing people who disagree with them. We don't currently have any cases against the federal government. We did have some during the Biden administration. One in particular around the Title IX regulations, which essentially said if you don't use preferred pronouns and if you have certain kinds of speech potentially questioning or critical of some aspects of transgender ideology, then you might be harassing people and therefore you can't say what you want to say. Those rules have been rescinded now, so those, the cases, they continue for damages purposes, but they're more or less, the issues have been resolved with those particular federal rules that impacted speech. So hopefully that answers your question. I mean, right now we don't have any cases against the federal government.
Would you say it's important to protect all opinions regardless of controversial, disagreed, extreme?
Absolutely. Yes.
No, I mean, you're the professional. I have no idea.
You use the word extreme. I think, the solution to, First Amendment people always say this, but it's true. The solution to bad speech is not silencing speech, it's more speech. Just, if somebody says something that's idiotic or extreme or whatever, the response to that should be, well, here's why they're wrong, as opposed to here's why they should shut up.
No, I love that point. And I guess my last question for you is most people just think political speech when it comes to the First Amendment. What do you think is most overlooked when it comes to the First Amendment?
So, I mean, at its core, the First Amendment is concerned with explicitly political speech, but that's not all that it covers. There's artistic speech, and there's any kind of speech. Frankly, it's like there's no distinctions drawn around more valuable and less valuable speech under the First Amendment. So, if that's what your question was, I'm not 100% sure.
What is artistic speech, if you don't mind me asking?
A painting or something, or a novel. I don't know. You don't see a lot of attempts to censor that, but there have of course been examples in history where governments have found a novel scandalous and then banned it. Those are important free speech cases. That's not so much an issue anymore. Maybe it is in some areas, but we don't deal with those cases too often.
Okay, I have one last one.
Sure.
If you were to leave the audience with one question to ask themselves in regard to protecting or changing, I guess, the current course of free speech, or just, I guess, start thinking more about it, what question would you have them ask themselves?
I guess I would want people to really think about this idea that speech can be harmful, and just try to think about speech that really upsets them, and then think about speech that they may that they may agree with that really upsets somebody else, and think about it. Should there really be a difference? I think people should be as consistent as possible in this area, and really question whether if you have the impulse to silence somebody, really think about it hard. That's what I would say.
Awesome.
All right.
Thank you so much, Jim.
Sure
We
thing.
appreciate your time. That was, awesome answers. Awesome getting to sit down and talk about free speech. I have literally no knowledge prior except for reading just everything up on you and the cases. So,
All right.
yeah, we appreciate your time. Thank you
Thanks
for
for having
coming.
me.
And this is another episode of Beyond the Bench. Nice, quick, and sweet. And we hope to see you next time for our next guest.
Thank you.